NACDL is the association of the nation's criminal defense bar.
Hi there. So my name is Nancy McGunn, and I'm one of many assistant federal defenders here in Detroit. And it's true, I was listening to the descriptions of all of the other speakers and was thinking, once again, I do not belong here. But then I remembered what I was talking about, and if I can't discuss sentencing, which unfortunately after 20 years at the Federal Defender Office, if I can't talk about that, then I have a bigger problem than my lack of, whatever. So what I'm talking about today is bringing the types of data and the information that amazing organizations like the Sentencing Project, the work that they do, and bringing it to life on behalf of our clients. I think what we have to first address is, are we talking about race at sentencing? And if not, why aren't we? Is it personal discomfort? Are we afraid of how the judge is going to receive the information? Or is there a deeper reason? Are we not seeking these issues out? Are we not looking for them because of our own bias? There are two articles that I put up on the screen that talk about implicit bias in the criminal defense bar and then specifically in public defenders. And I think they're very important reminders of what we need to constantly be addressing in our own practice. Because the reality is, unless we educate ourselves, we really are not in a position to educate the bench about our clients. So the first step before, sentencing is all about telling our client's story. Before we can start to tell someone's story, we have to learn it. And that takes incredible investigation and preparation. Our first meeting with our client always sets the tone for our relationship, right? And hopefully at that first meeting or soon thereafter, we have the opportunity to do a thorough interview. And we saw earlier a sample interview sheet. A thorough interview that is going to allow us to develop and to identify background information unique to our client. This is obviously hugely relevant during the entirety of the case, but particularly at sentencing. And we don't need to be learning this information 2 weeks before sentencing or right before we write a sentencing memo. We're talking to our clients, we're talking to their families, and we are generating a little mental to-do list of everything that we need to do to properly situate ourselves to make these arguments down the line. One aside, I am I process information visually. And so in order to remember a client's story and their family and where they're from and what happened to their parents and life expectancy and substance abuse issues and things like that, I tend to use either little family trees that I draw out myself. There are a lot of applications. This one is called Genopro. And we've sunk these into our sentencing memos when we've tried to track familial history of whether it's rates of incarceration or substance abuse or mental health. When we're trying to explain where someone came from, things like this. This is a super elaborate one. So maybe a little bit too much, but that can really present, really humanize our client to the court. So we know that we have to, it's not enough if we say it. It's not enough if we just talk about our client's history. We have to have the backup. We have to have the records to support our theory at sentencing. And so we have to start at the very beginning, pulling all of the records that we need. Whether that's education records that explain what happened to a client when they were disciplined in school, removed from school, and how that changed the trajectory of their life. Whether it's medical, mental health records, adoption, child protective services, but really important, police reports and pre-sentence reports from prior cases, so that we can start to have a picture of what our clients, if our client has a criminal history, why that might have come about, and how we can start the work of being able to explain to the court how our client arrived before them for sentencing. While we're going through this process, of course, we have to remain mindful of the circumstances and what our client is going through. For incarcerated clients, we have to pay attention to where they're incarcerated. What is that facility like? What is that experience like for them? How far are they from their family? What impact is it having on their own family, and are they receiving the medication they require, et cetera? For clients on bond, I think we don't always do a good job of really recognizing what being on bond, for instance, with a tether looks like. What it looks like to be on random Codaphone dialing in, where you can't keep a job because you have to call every single day. So remaining mindful of those issues. And for all clients, remaining mindful of microaggressions in the courthouse. For the clients who are in custody, this is a real problem in our courthouse. Many of our clients, the majority of our clients, are shackled in the courtroom for no reason. There is absolutely no reason that our clients should be shackled. And the message that sends to them, to the defense bar, to the judge, is really, really troubling. But as defense attorneys as well, the message we send to our clients and to the court, are we sitting with the prosecutor and chatting with them before the hearing starts? Or are we sitting with our client and their family? How are we playing into some stereotypes, and how are we helping to kind of minimize those microaggressions? And again, this work is hard. So this process of constantly being mindful and reminding ourselves of what our clients are going through allows us to avoid becoming numb and overwhelmed and desensitized. The point is, by spending all this time developing these issues early on, we might start to see a theme emerge of how our clients have been impacted by the types of issues that Mark was just talking about, by disparities in education, by racial disparities in how they might have been charged in a previous crime, or how they might have, the only plea bargain that was available, or the sentencing that resulted. We do all this work at the beginning so that when sentencing arrives, we know our client's story backwards and forwards. Nobody knows it better than we do in that courtroom. For us, for me, really, when I start to tell my client's story, that for me starts with the pre-sentence interview and the report. Because for me, I know what I need to say to that judge, the story I need to tell. But it's not enough for me to say it. I want all of my facts to be in that pre-sentence report. I want the probation department to say it, because again, the judge may look at me and say, but if it's written down and confirmed, it's a lot harder to ignore. And this is, in my practice, the first real opportunity for the judge to start to see my client's background. The key advantage we have is we know our client's story heading into that pre-sentence interview. We're familiar with their background. We know their familial circumstances. So we're in a position to supply the probation department with the information we need to be included in that report so that it's backed up. It can back up our sentencing memos. I do all of those interview sheets ahead of time. I don't know what your practice is like, but in the Eastern District of Michigan, we have that little probation packet. I do it ahead of time, not just because I'm a little OCD, which I am, but also because I know that the process of a pre-sentence interview is incredibly stressful. I was in court last week and I heard a defense attorney saying to his client, we're going to go do the pre-sentence interview now. It's not a big deal. It's take about 45 minutes. You'll have to drop at the end of it. It's not a problem. And it occurred to me that, the attorney had not explained to the defendant, listen, you're going to be sitting down and talking to a complete stranger about every aspect of your life, except for criminal history. They're going to ask you about your childhood. They're going to ask you about your parents. They're going to ask you if you sustained any trauma in childhood. Was there physical abuse, sexual, emotional? Did anybody have a substance abuse issue in your family? They're going to be asking you all these questions. That's really hard, particularly depending on who's doing the interview. And so we have the responsibility of preparing our clients for that, but also of having at our disposal all of the records we need to supply to probation if we feel that that report needs to reflect something in particular. And the example that I always kind of have to remind myself of, and I'm sure that everyone's had this experience, when you're sitting next to a client at an interview and a probation officer says to them, how was your childhood? Was it good? And your client says, yeah, it was good. And you're thinking, I don't even know what good means. Like, I actually don't even know what that means. And I don't know if it means the same thing to you as it means to me. But I'm here to tell you, your childhood wasn't good. It was hard. It was really hard. You know, your dad, and this was a specific instance, your dad was incarcerated when you were 5 years old, and your stepdad was murdered in front of your family when you were 12. You heard good, and what the probation officer was saying to you was, did you have enough to eat? Did you have a roof over your head? Did you have clothes? Again, I don't know what that means. That means something very different to everyone. And so, you know, those are the circumstances when you're kind of elbowing your client and saying, I think we need to explore this a little further and maybe explain what actually happened. The thing about pre-sentence reports and our clients' criminal history and their lives, we don't have the luxury of ignoring the bad information. We cannot undo multiple prior arrests. We cannot undo prior convictions, but we can explain them, and we can explain them in a compelling way. And we start again at the pre-sentence interview and report. So if the client has a number of prior arrests, were they in the same neighborhood? Were they the same officer? Really flush out what that looked like. In our pre-sentence reports, you know, depends, it's the luck of the draw. It depends on who you get that writes the report. And when Mark was describing that young man who sustained a series of relatively minor convictions, in a pre-sentence report, that takes on a whole different picture, depending on who your judge is. And I had a case, my client was young, he was 22 years old, young African-American man, and I knew that the judge was going to have an issue with the types of prior conviction and the number of prior convictions that he had. And I could hear in my head that he was going to say, and this is just a path, and it's just getting worse, and we don't know what's going to happen. And as a result, you know, we need to address this case before the defendant really, you know, progresses to a much more violent future. The pre-sentence report initially was devoid of information. Meaningful information about the prior convictions. So it would say there was a larceny, and on this day he pled guilty, and this is the sentence he got, and he violated probation. And it went on and on and on. We had the probation department add, and I'm sure you can't read this, so I'll read the part of it to you as it related to a specific larceny conviction. And the reality was, every single one of this client's police reports read the same way. In this case, it was a larceny. He was at a hospital, an iPhone and a little scanner were stolen off of the valet station. They look at the video footage, they figure out that it's my client, they find him, he's confronted, and he's arrested on outstanding warrants. Police report indicated he admitted to officers that he stole the phone because he had only $5 to his name and no one would hire him. He stole the phone to earn money for his expanding family since his girlfriend was in the hospital to give birth to their child. Those are facts that, to me, really present a very different picture of my client than the picture you might get if it just says he pled guilty and he violated probation. And let's talk about why he violated probation, right? In our district, all the time we see clients coming from state court who violate probation or parole for a variety of reasons, lack of transportation. If you owe fees, you haven't paid the fines and costs. And as a result, those violations sometimes aren't clearly explained in a pre-sentence report. Another example, I had a client, young client, zero history of violence. Had one prior, this was a gun case, had one prior conviction for pills. And it wasn't even, there was no gun in connection with these pills, they happened to be found in his car. So now I have him on a felon in possession case. And I know what the government's going to say about him. I know it because they said it at the detention hearing, and I know it because they've been saying it to me throughout the case. And they're going to try to present my client as violent. And I'll get into that why in 1 minute. So we get the pre-sentence report, and out of nowhere, the probation department has inserted this language dealing with a prior domestic violence arrest. It's, again, I'll read you the relevant part, but you know, this is a client, again, zero violence, who's still with the girlfriend who's in this report. This says Jasmine reported she was assaulted after an argument. He accused her of cheating, punched her in the left eye. She contacted emergency services, but later canceled it. A few hours later, she told him she wanted to break up. He became upset. He was kicking. He broke down the bedroom door, threw a chair, smacked her face with an open hand. Detective attempted to follow up and was unsuccessful. Client insisted that did not happen. Client's girlfriend said that did not happen. I have an old nosy neighbor who was sitting on her porch while we were yelling at each other about issues in our relationship. Yeah, he broke the door for sure, but no way did he ever hit me. So we had the probation department contact the girlfriend. We actually had the girlfriend contact the probation department, and all of a sudden, the description changed. All of a sudden, none of that stuff was in there about him hitting her. What is in here is two people having a relationship skerfuffle and, just kind of getting at it, but it presented such a different image of my client, and it presented an image that was really consistent with who he was and who I needed the judge to see him as. So in terms of sentencing, and when I'm talking about sentencing, I'm talking about both a sentencing memo and I'm talking about what we say on our client's behalf at the actual sentencing hearing. We start with a plan. It's not just this random, idea, collection of thoughts. We start with a theory and a story of our client's life, and we weave everything into that story. We take the types of issues, actually I'll get to that one in a second, but the thing about sentencing memos that I want to say is we don't just rely on black and white text in a sentencing memo, on standard language, on sterile language. We insert photos and videos and audio clips. We talk about when we attach letters of support, we don't just attach them to the back because we're trusting that the judge, after reading the memo, is going to read all of those letters. If it's important enough for us to submit, it's important to snip out the little portion and sink it right into the memo so that the judge has no choice but to read it. He or she cannot ignore it. And with respect to sentencing, we have the advantage of knowing our client's story. We know the background, the circumstances of prior criminal convictions in a way that the government just doesn't. The example, the domestic violence arrest that I was just talking about, this was a client who was a young African-American male, and he had come to the attention of the federal law enforcement officers because he was really active on social media. And I don't know if you are seeing any of these cases, but he was all over Facebook and Instagram. He was an aspiring rap artist. So he was all over Facebook and Instagram posting videos of himself rapping, unfortunately also posting videos and images of himself with what appeared to be firearms and copious amounts of marijuana. So he came to the attention of law enforcement. They latched onto it and end up charging him with felon in possession. The government's story about him was clear from the very beginning. Look at these images of him. He's so violent. He's so angry. He's prone to violence. He had a gun. This is who he is. This is who he was. This is who he's always going to be. So when we got close to sentencing, I wasn't entirely prepared for how bad the government's memo was going to be, although I anticipated some of it. The government's memo started with this, and I don't know if you can see this, but this is my client with 3 firearms and a quote from a video he had posted. And the quote is, they'd be like, boy, you tripping on Instagram, you're gonna catch a motherfucking Fed charge off Instagram, everybody tell me that shit, I don't give a fuck, pardon my language, I don't give no fuck, they gotta find me and then they gotta catch me, I'm not gonna lie to you for real. So this is what the government led with. And unfortunately, a fact that was hard to deal with was in fact that when they did find my client, he in fact ran. So they did have to catch him. So this is how the government wanted the court to see my client. And if you can't see that image, it's a little bit blurry, but he looks serious. He has these 3 firearms. This is how I needed the court to see my client. These are images of him with his child. These are images of him at work. And I needed these images to be in the forefront of my memo because I needed the court to understand that my client drove this child to preschool every day. My client worked at that job because it was the only job he could get with a felony conviction. And that's who he is, not who the government is trying to tell you he is. As an aside in that case, the government, my client had posted various phrases along with some of his images. And they were phrases like, you can see the devil in me. And what the government failed to realize is those were rap lyrics. I mean, I Googled them. They were just lines, right? Like, and this was easy to figure out, frankly. The government actually took those phrases and said, look at this guy. He is so violent. He is so angry. Because, you know, we explored this in the sentencing memo, because rap as a genre of music is treated very differently than other genres of music, right? So it was viewed as a promise of action. It was viewed as, this is who he is, this is what he wants to do, even though his personal history was devoid of any indication of that. And this was an artistic expression. So we were able to pinpoint each of those phrases and show where they came from, and some of them were his own lyrics as well. So we know from what we've been talking about the last day and a half, that our client's story begins well before the offense conduct, and that it's heavily impacted by environment and geography and familial circumstances and everything. When Mark talks about flushing out the neighborhood or the community that an individual comes from, we need to explain to a judge what the circumstances of our clients' lives. Did they grow up in a community where there was high crime? What was the access to education? What was the per pupil spending? What happened in that community? What did our client's early life look like? And the Bannister case, I don't know, I'm sure most of us are familiar with that. It's a case out of the Eastern District of New York, and what I'm referencing is actually the sentencing opinion. It's an over 100-page sentencing opinion where the judge took an exhaustive look. It was a multi-defendant drug distribution case. The judge took an exhaustive look at the defendant's circumstances of life. They had come from a public housing. They had all been raised in the same public housing project. What did that look like? What was life like on a daily basis? What was the access to education? What was the life expectancy in that neighborhood? Were there particular physical health issues? What were substance abuse issues? And then the opinion goes on to address everything from the evolution of drug laws to mass incarceration. But it's a great example of how we need to bring our clients' stories to life for the judge. There are great resources, the Sentencing Project obviously being chief among them, but NPR has an interactive map on life expectancy. The Uniform Crime Reports can give us data. If you're talking about a particular neighborhood that your client came from, do a Google search. See if there are news articles that discuss what was going on in a particular environment or area that your client comes from. With respect to education and talking about economic disparities and gaps in access to education and funding and teacher equity, you know, obviously it's easy to pull the statistics and the data on per pupil spending and how that ranges from area to area. But in discussing the actual impact on clients, I had a case where my client's mother provided a statement that we took and inserted into our sentencing memo because she talked about what it was like every year to go to her son's school, which was not well funded and had a lot of issues, and to say to the principal, he cannot read. He had lead poisoning as a child. He's got learning disabilities. He cannot read. And to have every year her child passed on to the next grade. And taking that and then explaining to the judge why in 7th grade he just gave up. It was just too much. The frustration of essentially showing up every day in an environment that did not address who he was and what he was dealing with. And then the impact that dropping out of school had on the rest of his life, on his criminal history, et cetera. You know, we talk about the school to prison pipeline because we know that there's immense racial disparity in how discretions and disciplinary issues are handled in school, whether they're dealt with within school or referred out. We know that there is great disparity in what happens. Are you given a minor infraction, detention, et cetera, or are you expelled and suspended? And what does that do in terms of your trajectory? The Office of Civil Rights, it's the Department of Education, has a great breakdown in terms of gender and race and ethnicity, and looking at the range of disciplinary actions that apply. So if this is your client's story, if this is part of their story, it's very easy to back up, to pull that data and then to describe exactly what happened to your client when he or she couldn't return to school. The impact of incarceration on family, there are, and this is later, what I'm talking about too is pulling the resources from the sentencing project, pulling social science articles. You know, SSRN, the Social Science Research Network, has incredible resources that can back up all of these theories. And again, it's not enough when we say it, but somehow if you slap a PhD at the end of someone's name, the judge is going to really accept it. And so we're telling our client's specific story, but we're also tying in all of the issues that we're talking about. If the client has multiple repeated stops, traffic stops, why is that? Is there a particular neighborhood that the client was being stopped in? I cited the Minneapolis Police Department just posted in an attempt at transparency a tool for the public to examine the frequency with which officers stop people based on race, ethnicity, or gender, and it's refreshed daily. But talking about, not just ignoring that fact for the court at sentencing, actually talking about why this happened. Prior convictions. We know that clients are put in the awful position sometimes of accepting a resolution, a plea, when they just simply aren't guilty. And they describe prior circumstances to us of how that occurred. And it's an uncomfortable situation because you think, oh my God, you know, you're waiting for the judge to say, was he lying then or is he lying now? You know, what was it? But the reality is there are very compelling reasons for why people who aren't guilty plead guilty. And the two resources that I cited there describe that. In terms of prior convictions, you know, at sentencing, providing a different perspective and a different version of what was occurring in a client's criminal history. A client who has multiple prior drug convictions, all of them were state, all of them occurred in the same neighborhood. His neighborhood happened to be terrorized by a group of police officers, and these officers were later federally indicted. His description, his little narrative, and his mother's description of what it was like every day to come home and to see this police car sitting in front of their house and what was going to happen, and the indignities visited upon their family, and there was no recourse. And what that did to my client's view, obviously of law enforcement, but his children's view, and how that led to this racking up of criminal history was very important to point out to the judge. Driving while licensed, suspended, or revoked, those are convictions that generate criminal history points in federal cases. I don't think judges really grasp sometimes what it is, how much it costs to have your driver's license restored, right? So then what is it? Do you not go to work? Well, you have to work. Is $2,000 in driver's restoration fees. You have to get your children to school. So, you know, who is picking up the vast majority of those convictions? There's a book called On the Run by Alice Goffman, and it really presents a very interesting picture of what it's like to live in warrant status. And the reality of why that happens to our clients. We have judges, there's one judge in particular who is at sentencing always troubled by the outstanding warrants that a client has. So to go through and to explain what this, you know, why this occurs. And Justice Sotomayor, that quote from Utah v. Strife, it's a dissent, her dissent, and it starts out with, outstanding warrants are surprisingly common. And it goes on to explain how easy it is to violate probation and have a warrant issued, and then kind of the domino effect and what that really communicates about a client's situation. We talked about the use of social science articles, and you know, as Mark was saying, when we're talking about our client's story, we're explaining to the judge how racially discriminatory decisions that have occurred at all different stages, past cases in this case, implicate sentencing issues. Whether that's charging decisions, if a client was charged, state versus federal. We talked a little bit about that Armstrong case yesterday and the high bar that it set for selective prosecution. There's a subsequent case, and I think it's it's a Massachusetts case, where the defense counsel actually overcame that burden and was granted the discovery necessary to show who was getting charged with drug offenses in state court versus federal court, because they were able to meet that baseline showing of racially discriminatory practices. Talking about bond determinations and conditions, if our clients are unfairly being subjected to conditions, and if there are differences in how our clients are being treated, whether based on race, charge, et cetera. Mark talked about the domino effect of, unfortunately, all of this comes to play later in life, right? In federal court, we have a diversion program. That diversion program is only accessible to people who have no criminal history. So by the flip of a coin, right? But not really the flip of a coin. Unfortunately, instead, it's a racially discriminatory decision about how a client's case 5 years ago was handled, then prevents them from having access sometimes to these alternative programs. In terms of habitual offenders, the U.S. Sentencing Commission has great data on their website, and this is specific to career offenders, that clearly explains who is being subjected to career offender enhancements. So we talk about, career offender is a habitual enhancement that's based on how many priors of a particular nature that you have. Why is it that certain clients, why is it that 60% of the individuals subjected to or eligible for the career offender sentencing enhancement are in fact Black? We have to look at how prior cases were dealt with and how that triggers eligibility. The U.S. Sentencing Commission has this interactive Sourcebook that is searchable in various ways, has drug data and demographic data based on race and ethnicity and age and gender. And it's a very useful resource. So the challenges during the pendency of the case, we also have to remind the court about what our client has dealt with during the case and what the real impact of a conviction and of imprisonment are. We have to talk to the judge about felony disenfranchisement, the loss of federal benefits, the loss of access to student loans, et cetera. We have to walk the court through what it looks like for our client's family that they've been incarcerated for 6 or 9 months or a year while the case has been pending. I know that in the next session they're going to discuss collateral consequences, but again, I'm not sure that our judges really grasp, for instance, the incredible difficulty in securing employment and the long-reaching consequences that, forget about imprisonment, forget about absence from the community, just the conviction itself can sometimes have. In terms of elocution, I don't know that we, and by we I mean me, spend enough time preparing our clients for elocution. We get to sentencing, we've done all this work, we've put all this work into our sentencing memos, we know what we want to say, but I don't know that we always give enough thought to preparing our clients to speak on their own behalf and to have the judge hear their story from their mouths. There was a journal article a few years ago, and it was a survey and an analysis of federal judges' views on elocution. And whether we agree with those views or not, it's really important to hear them because this is my audience. So I have to understand and anticipate how they view my client's statements on his or her own behalf. And I need to adequately prepare my client for that. The last thing that I want to leave you with in terms of sentencing is, the client, I had described the client that had all those kind of relatively minor prior convictions, the larceny. That was a sentencing that took place almost a year ago today. And that was a case that was very difficult for me to prepare for sentencing. It was difficult because my client was 22 years old and was facing a really long time in custody. And he had been raised by his grandparents. And I had the feeling that if the judge imposed the sentence that the government wanted, his grandparents would probably die while he was in custody. They were quite old. And I looked at him and I didn't know how he would survive this. I didn't know that he would really make it through the lengthy custodial term that the government wanted. And it was concerning. So I put in a ton of effort into a sentencing memo, and I talked to family members, and I looked through each and every one of those prior convictions, and I explained every single one of them to the court in the sentencing memo. And I showed up for sentencing that day, and I was ready to go, and I prepared my client for what he was going to say on his own behalf and what he wanted to hit home for the court. And the judge called us back to discuss a legal issue in the case. We discussed the legal issue. I was so ready to go. And the judge looked at me and said, oh, and by the way, Nancy, I just wanted to let you know, I read your sentencing memo, and it did not make me sympathetic towards your client at all. And I was like, oh my God, that is hideous. It's hideous, number one, because my first thought is, man, did I not do a good job, even though I spent all this time. My next thought was, my client and his family are in that courtroom, right? And you don't see him. You don't see him. You don't see his history. If you're gonna say that to me, this is awful. So I had a choice about how to handle the elocution part of my sentencing hearing. And I went out and I ignored what the judge said, and I said everything that I had planned on saying, and then I added some few things just to stick it to him. Because, I was once again, right, given this view of, yes, I am making these sentencing arguments. Of course I did that because I was hoping that the judge would maybe hear something different this time. Maybe I could tweak his mind, maybe just a little bit I could change his mind. But I was also saying it because the prosecutor needed to hear the arguments that I was making on my client's behalf. But more than anything, my client needed to hear it. My client and his family needed to know that while this judge may ignore everything that mattered, frankly, about him, I didn't, and it was important enough that I stand there and advocate for him. And that's really all I have to say about sentencing.